Hello and welcome back for the Friday 5 for October 7th, 2022. Here in Minnesota, things are getting a little bit chillier. The weather was down in the 30s today, so we're a little bit colder, but hoping for some warm weather next week. Today we've got 5 questions, a couple on estate planning, a couple on business law, and one on a family law. Interesting case that came across my desk this week. So let's dive right in. My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. And let's look at the Friday 5 for this week. First question that came across my desk that was pretty interesting this week is, what happens when there's no will? Who inherits property when somebody dies without a will? Well, this is a pretty basic part of estate planning that we have to deal with, and this is when it bleeds over into the probate court. When you die without a will, it's what's called intestate, is the legal term for it, meaning nobody left a will behind, or there was no valid will that was left behind. So in this case, what we found was that there was a will that was written, but it was not actually valid. So now we have to turn to the question of, we have a will, it wasn't correctly signed, but can we use that as the basis for who will inherit under the will? So if somebody dies without a valid will, what we have to do is look at your local state statutes. They will tell you who will inherit and what they will inherit and the way the estate will be divided if somebody dies without a will. Question number 2 for the week. Should you divide your assets with specific money or percentages in your estate plan? Now, we can look at this 2 different ways. If you have a specific amount of money you'd like to leave to a charity or to a person, that's definitely one way you can do it. But a lot of other people were looking at what we call the residuary of their estate. After we've done those specific gifts and we're dividing up amongst, let's say, our siblings who are still alive. Some people will say, well, I want to give $50,000 to each of my brothers, and there's 3 brothers. Well, that's fine, but we have to make sure there's going to be $150,000 left in your estate that can be distributed to them at the time of your death. Because if there isn't, then the court's going to have to sort out how much is everyone getting. Is it supposed to be 1/3 each? We have to look at the specific bequests in the will as well. A more common way that my clients will do it is if we have 3 brothers remaining, say, I will split what's left in my estate after all of our specific gifts, 1/3 to each brother. And if one of those brothers dies before I do, then the next question you have to ask yourself is, do you want their share to pass on to their kids, or do you want their share to go to your other brothers? And so if it goes to their kids, then their 1/3 goes to their children. If it goes to the other brothers, then the 2 remaining brothers each get 1/2 of what's left, as opposed to the original 1/3. Friday 5 question number 3 for this week. What parts of your LLC formation process can you do for yourself? So the answer is you can do it all yourself. So creating an LLC, forming companies with the state where you're located, you can always try to do it yourself, but I don't recommend you do that. So this week I met with a few different clients who wanted to know, could they do this themselves or do they need a company to do it? And the big thing they want to look at is, what part of the process are you in? So one client had actually done all the formation documents himself. Everything was set to go. Now we actually had to deal with New York's publication requirement. Well, the publication requirement can be a bit of a hurdle in New York, and if you set up in New York City, it can be very expensive. So that client wanted to bring me in to try to fix that particular situation. The other thing you want to look at is if you're setting up an LLC, for example, to own rental property, you're not just doing your LLC agreement, but you're also going to have to deal with moving the property into the LLC, and that's done with a real estate deed. Now, once again, you can try to do a real estate deed yourself, but I don't recommend it, because if there's any problem with the process, if you do the wrong thing, you could be messing up the title to your property, and you could be creating a lot of problems for yourself down the road. So you can go to these websites and they'll give you different forms and say, sure, you can do it yourself, just pay us. Now what you need to realize is they're marking these things up. So when you file that LLC with a company that's supposedly helping you, and for example in Minnesota it's $155 for you to file for your LLC. Well, if you look at the online websites, they're charging you $175, $180, $195. And letting you know that's your filing fee. But what it really is the $155 plus their fees on top of it. If you work with an attorney, if you work with companies that are doing the legal work for you, then you shouldn't be paying more than the $155. They're just tacking on money for their services and marking up filing fees. Question number 4. Should you just ignore a lawsuit that's served on your company? I had an interesting call this week with a client who runs a company, and the company had been sued, and the company didn't do anything about it. Didn't hire an attorney, didn't file an answer, and now the company has a judgment of over $100,000 against them. Now, that's not a situation any company wants to be in, but it's further complicated by the fact that the owners of the company actually personally guaranteed that debt. So now, not only does the company owe that money, but the plaintiff can actually go after the individual owners of the company because they personally guaranteed that debt. So, and we've talked about this on prior videos, the most important thing, especially whether you're a company, whether it's an individual, if you've been served with legal papers, do not just ignore them. You never want a default judgment taken against you. It's much harder to come back years later and try to undo that judgment than it is to show up immediately and say, wait a second, I may or may not owe this money. And if you owe the money, you may be able to at least work out some kind of a payment plan with the plaintiff so you're not stuck with a big judgment against you down the road. And the last question for the week, number 5, going back again to what can you do yourself, was can you create your divorce forms yourself? So this week I had a meeting with a client who had created a separation agreement with his wife years ago. And when I looked at it, it was a really strange form. I couldn't figure out what was going on until I got to the very end on the last page where it showed me which website it had been downloaded from. And in looking at that, you can see that it's not a state-specific form. It's not necessarily appropriate for the state where the client wants to file for divorce. In the state where this was, there's very specific language about child support, about alimony, about property divisions, about health insurance. All of that language was absent from this online form they'd found. Now, they may get away with it if they try to file the divorce themselves, because the court may look at it and say, well, I can kind of figure out what they were trying to do. It was just it was a young couple who didn't really have a lot to divide up, but they just wanted to get divorced. But the fact is that online form could really come back to bite them because they signed their separation agreement before the pandemic hit. So we're talking 3.5 years at this point, and they've been living under that agreement. Well, what's going to happen if the court looks at it and says, this is not an appropriate agreement, and throws it out? Now they're going to be back to square one, and they may have a very different negotiation as to how to resolve their divorce actions. So that's our Friday 5 for this week. Inheriting when there's no will, dividing assets by money or percentages, which parts of the LLC process you can do yourself, should you ignore lawsuits, you should not ignore lawsuits, and whether you can create divorce documents for yourself. If you'd like to submit questions for upcoming Friday 5s, you can check the link below. It'll be in the comments and it'll be in the description of this video as well. You can go to my website where there's a section to submit questions for the Friday 5. Also, if you'd like to set up a strategy session, go to my website, andrewmayers.com. We can set up a legal strategy session. It's about 15-20 minutes, and we could talk about your legal issue and get you some options and next steps to help you get through it. I hope everybody has a wonderful weekend.